Welcome to the Taxpayer Podcast, a podcast production by the Taxpayer. For more informative discussion on tax law, please visit our website to learn more about the Taxpayer Journal.
Peter, nice to see you again. It's been a while, but here we are. And hopefully we'll have something of interest to say to each other and perhaps also to those who might be watching this in the fullness of time. One of the things that's happened since our last podcast was new tax rules have been published and promulgated, effective from the 10th of March 2023. And I think I was in court on my feet on 2 days or 3 days later, referring to the tax court rules, blissfully unaware of the fact that had been changed. Seems like there was virtually no consultation, or one wasn't aware that it was coming. Anyway, there are some important changes, and let's have something to say about that. And then there's also a recent decision of the Constitutional Court, which might be worth talking about.
I see you've caught up quickly though, Trevor, because the Taxpayer has brought out the tax court rules, and I know you've got your own set there as well.
Yeah, so, indeed. They look remarkably similar, don't they?
They do look very similar. And it's quite impressive that if you weren't aware of them at the time, that very shortly thereafter, they are actually in print and hard copy. And yeah, they are looking lovely, and a nice pocket size as well that you can kind of carry around with you. So no excuses for getting them wrong going forward.
Oh, that's the idea. So if I may just say this, this is not a forum for sales, but these are available for 350 Rand each, which includes value-added tax and delivery by courier to whatever address. And it's quite convenient.
Convenient. I think the first, maybe the place to start is the extension of the period to lodge an objection, which has gone from 30 days, been 30 days as long as I've been practicing law, to 80 days. Oh. And that's business days as well. So that's a substantial increase in time in order to lodge your objection. And I don't know what your sense is, but I think that's very helpful to the taxpayer.
Absolutely, yeah. But it might be too helpful. It's so long that you forget about it, and then you end up not complying. So that would be Rule 7.
I think that's right. Do you know what
Rule
it gives
7,
you?
The taxpayer who may object to an assessment under Section 104 of the Act must deliver a notice of exception within 80 days after, and then the same things. That's a long time.
It's business days, which is even longer than, obviously calendar days. But you know what? It gives you time to prepare your suspension of payment application. And we chatted about that previously. I always say when you get your additional assessment, the first thing you should think about is not your objection counterintuitively. It's your application for suspension of payment, because as we all know, the tax debt arises on the date of the assessment. So as soon as you receive the assessment, you owe the money, and you don't have to pay it if you apply for suspension of payment. So you need to get your suspension of payment application in as soon as possible after the additional assessment. And now you can focus on that instead of worrying about your objection and watching the 30 days sort of tick past. So I think that's quite a sort of a side benefit of this extension of time for the objection.
In terms of calendar days, how long would that be? 80 days, it's probably approaching 5 months, something like that.
Yeah, it is. And just a warning on that as well. There are a couple of electronic calendars that compute business days, and sometimes they get it wrong because of public holidays, etc. So just use your fingers and thumbs and get onto your calendar and do it manually. That's nice. Maybe I'm old-fashioned, but that's my way of doing it.
I always do it like that.
Something you don't want to get wrong.
I've had to ask condemnation from the Supreme Court of Appeal for being 1 day late. It's such a palaver, and it's so unnecessary.
And we talked about, just talking about timelines for a moment, Trevor, we've talked about the Rule 56, and that deals with what happens if you are non-compliant with your timelines. Yeah. And the other party, if it's SARS, it's non-compliant, the taxpayer can then go to court and require SARS to comply with the timeline within 15 days. It's 5 days. And if they don't, you can get a final order from the court. And we talked in one of our previous podcasts about a judgment where there was default judgment obtained against SARS, and the assessments were effectively nullified by the court. So, timelines are important, and you can apply for condemnation, etc. But this Rule 56 is always something important to keep in mind.
Absolutely, yeah.
It's not a slam dunk. Chance of going to the court and saying SARS was sort of 1 day late, and I want to get a default judgment, and I want the assessment to disappear is very unlikely. As I said, they have 15 days to remedy their defect in the first place. But if they don't do that, and there's been a history of non-compliance, then you can get a default judgment. So timelines are important, and this sort of 80-day extension is great, I think.
Yeah, I think sometimes strategically giving SARS a few extensions is good, because when they don't comply with them, then you can come more forcefully for a default judgment. Yeah.
There's a lot of strategy in sort of managing that, the tax dispute process, and you control the timelines, so I think, you should always be compliant with them and aware of them, and there's really no excuse for not, for sort of not complying with them, and especially now that we've got this sort of long extension. But as you said, Trevor, apropos your first comment, I don't remember any consultation around this. I mean, it's lekker to have 80 days. I don't know where it came from there.
I know. And another thing that's very similar are these amendments in relation to trusts, which is a totally separate topic, which I think we must discuss in a future podcast. But again, that was promulgated on the 31st of March, effective from the 1st of April, and nobody knew about it.
Yeah.
And quite apart from that, it doesn't make sense, but we'll talk about that later.
Another day.
Yeah, so that seems to be the new style of the government. You just enact things, don't worry about consulting or announcing that it's going to be.
We lawyers have to stay on our toes, Trevor. We need to kind of be super up to date with stuff. Yeah. I see the Rule 31 dealing with, which is kind of the start of your pleadings, I suppose. If you think about the tax court as a high court, you kind of start your pleadings with Rule 31. SARS, and I see there SARS have now got the ability to include a new ground of assessment in their Rule 31 statement, setting out their grounds for not allowing your objection. So they may include a new ground of assessment unless it constitutes a novation of the disputed assessment. But that's quite a wide, I don't think you've seen that in practice. It's kind of SARS always changing their mind, where they kind of go through the question and answer session with you or process with you, issue the additional assessment, you object to it, you give a long detailed objection, and then SARS disallows it, you note your appeal. So you go through all of that process, and then the Rule 31 statement from SARS starting their pleadings, they can include a new ground of assessment. That's worries me a little bit.
Yeah, but wasn't that in the previous rules as well? I think it's just been rephrased.
I think it's been rephrased.
Yeah.
I think it's been rephrased. And that's why I'm quite interested, because I have seen it quite recently, sort of a new ground popping up at the Rule 31 stage, which is not ideal, because you focus very much on, as I said, the earlier process, which is quite long and arduous in itself. I don't know if you come across that. It's kind of, it seems to give a lot of scope to SARS to kind of change their mind as they go along.
I've come across it quite, in fact, got two matters pending. Rule 32.3 from the taxpayer's point of view. There's a similar provision. And there's also a very recent judgment of the Supreme Court of Appeal. It's Commissioner for the South African Revenue Service versus Free State Development Corporation. It was handed down on the 31st of May. And that was concerned with a new ground that the taxpayer wanted to rely on. And the fact, I don't think it's appropriate to discuss the facts of the case. It would take a long time, but I think that judgment is very favorable to the taxpayer.
It's interesting.
I mean, for example, perhaps we should just let's read Rule 32.3. It says the appellant, so that's now the taxpayer, may include in the statement a new ground of appeal unless it constitutes a ground of objection against a part or amount of the disputed assessment not objected to under Rule 7. I think previously it said the appellant may not include in the statement, I think, unless it's so. It's very difficult to see what the change of meaning is, but it's just it's more permissive than previously. It was saying what you can't do. Now it's telling you what you can do. But the criteria seem to be the same. I mean, just one example, because I can mention this very quickly. I was involved in a matter, and we did take a new ground of objection. A new ground of appeal in our Rule 32 statement, and we were upfront about it. We said we were taking a new ground, and we said we thought it was permissible in terms of Rule 32.3. SARS then filed a Rule 33 statement and took issue with that. And the matter went to court as an interlocutory application. And in fact, SARS was successful. And we're now taking that decision on appeal. And I won't go into the merits of it, but what happened was the taxpayer had claimed an amount as a deduction from its income. And the new ground was that same amount ought to be excluded from its gross income because it wasn't received for the taxpayer's own benefit and on its own behalf. It's exactly the same amount. So the effect on taxable income is identical. And the court held it because it's because you're talking about gross income instead of a deduction. Therefore, it didn't fall within the previous objection. You have to have regard to the part of the objection or the amount. Now, the amount here was the same. But anyway, I'm not going to argue the case on this podcast, but that's the sort of thing that can arise.
And as you say, this seems a bit more permissive because in your Rule 32 statement, you can include a new ground of appeal on the face of it. So that's the permissive part. And then it says, unless it constitutes a ground of objection not previously objected to. So there is a restriction on it, but it's nice that the appellant can include a new ground of appeal. That does give you some flex, I think, that you might not have had previously. But yeah, it just shows that until pleadings are closed, you don't know exactly where either party is going to go and what they're finally going to be answering. So the kind of the rules can change a little bit, or the game can change a little bit as you progress through the pleadings, is what I sort of pick up from this.
Yeah, I mean the limitation is the appellant may include in the statement a new ground of appeal unless it constitutes a ground of objection against a part or amount of the disputed assessment not objected to under Rule 7. And in that regard, again, without focusing too much on this, it's relevant what an assessment is. An assessment is determination of tax liability. So I would have thought what matters is taxable income, because that's how your tax liability is determined. Anyway, let's not get too specific.
I see there's changes to the alternative dispute resolution proceedings as well to try and achieve a more collaborative process regarding appointment of facilitators and things like that. Trevor, do you do ADRs, Trevor, and are they successful? Because I mean, I must say, I haven't done an ADR for probably 5 or 6 years. They typically, I think, come up in kind of slightly smaller matters where you think it's something silly to be arguing about. You go in front of the facilitator, and it's almost a sort of a mediated settlement between yourselves and SARS. But I must say, I don't see a lot of them happening in sort of bigger litigation matters. And I personally haven't been involved in one for several years now. I don't know what your experience is.
Yeah, I have done a few, but it is just a few. And I must confess that I'm fairly cynical about them, because generally speaking, it's proved to be a little more than a waste of time. However, let me qualify that by saying that our fellow editor of the Taxpayer, Ernest, tells me that his approach to ADRs is to keep lawyers away. So It's a horse trading session, and it's better to have accountants there, and you come to some sort of settlement. Keep the lawyers away, because then it's adversarial. And he claims that it's been quite useful, but that's not been my experience.
But I think there's sense in that, because I think it is a bit of horse trading, and there's a little bit of give and take. And I think if you get too lawyerly and you come with your legal arguments and you want to have a good old debate and you want to start cross-examining people, then it's not the forum. It's just not the forum. People,
and everyone
it's
just
a settlement.
entrenched in their own position.
100%. And the poor old facilitator sits in the middle of big eyes and wonders, when the tea break's coming. So I think that does make good sense to me. And I think these amendments to those processes maybe will assist, if it is more collaborative, because I think that's the point, Trevor, that ADR needs to be collaborative. It's not a litigation forum. You must go there to be collaborative. If you don't want to be collaborative, stay out. So maybe these changes will help there.
But perhaps you can help me here, but is one of the changes that the facilitator can be an independent person? Because Rule 16 says a person appointed as a facilitator or alternative dispute resolution proceedings of ADR under this part A may be a SARS official. It doesn't say must be a SARS official. And must be a person of good understanding who has appropriate experience in the field of tax. And D must be acceptable to both parties. I think that is new.
Okay.
That is quite a change.
I think the knowledge about tax is important as well, because I've been done an ADR moons ago with a facilitator knew nothing about tax, and that's not helpful. You can be as good a mediator as you want, you need to understand what the issues are, and it goes up to the tax court as well. You'd want to be appearing in front of a judge in the tax court who actually knows about tax. I mean, that's hugely helpful. It's a very specialized, complicated area. And I think the same sort of trickles down to the ADR. You want your facilitator to be someone who knows about tax. So it must be helpful.
I must say, I can remember two specific instances, but this is now a long time ago, like 10 or 15 years ago, where the one facilitator, where I remember who it was Judge Galgut. He was a Durban judge, and he did all the tax cases in Durban. And he then retired, and he was the facilitator in an ADR. And it was such a pleasure talking to someone who knew exactly what you were talking about. Wow. And I would imagine that SARS had the same experience. But
it'd be a game changer.
Yeah, but more recently, it's just somebody, you have no say in the matter. But it seems like that has changed.
Interesting. Well, let's watch this space and we'll report back.
Indeed, yeah.
And then I see, to your point, Trevor, that you were kind of standing in court and the rules, sort of apply to you as you stood up, because the transitional arrangements are not really transitional. They kind of just say it sort of applies immediately, provided the time period in respect of your particular, wherever you are in the proceedings, has not yet expired. So they became effective immediately. There wasn't a lot of time to sort of, process the changes.
So if you had an assessment, under the old rules, you had 30 business days to object, and let's say 25 of those had gone by. Then the 10th of March arrives. Now suddenly you have 80 days.
Because the time period has not expired. You were exactly. You were still in the 30-day period.
Yeah.
So, that just shows everyone needs to be very clear that these rules have arrived. There's nothing prospective about them. We're in. Doesn't change any of the stuff we talked about as well. Reviews, declarators, that's outside of this process. You can go directly to the High Court for declarator or review under PADJA or under principle of legality.
Yeah.
If you go under PADJA, obviously you need to exhaust your internal remedies. We've chatted about that before. And we're still waiting for the outcome of the ABSA case. And that's now been, by my count, around 3 months. That's quite long for the SCA, isn't it?
It is. It certainly is, yeah. But I've got some insight into it, because one of my colleagues did a case in which he asked the tax court to review something, and what the argument was, and I've had nothing to do with this case, so I'm trying to remember a conversation, but the problem was that the taxpayer's case was that SARS had not followed the process applicable to an audit. They've got to, there's certain procedural things that they have to do. And that case raised the question of what's the difference between a verification and an audit, and if something might start as a verification but it becomes an audit. Anyway, the taxpayer asked the tax court to review that decision, and the tax court said they didn't have jurisdiction. You must go to the High Court. So the taxpayer then went to the High Court, and the High Court said no, it should have been heard by the tax court, and they declined to exercise their jurisdiction. An application for leave to appeal to the SCA was made and declined, and now there's application for leave to appeal to the Constitutional Court, but it raises similar issues to ABSA, and there are two other matters also involved. So it's almost like there's a lot riding on it, put it that way. There are about 4 different matters, all involving the same point.
Exactly. And I think everyone's waiting for the SCA to see which way they jump in ABSA, and then everything will fall in place from that. So I think once the SCA judgment in ABSA comes out, there'll be a whole lot of judgments coming out. We're waiting for 1 or 2 as well. And I think everyone's sort of, as I say, sort of holding their collective breath for the SCA to pronounce in respect to the ABSA matter. So let's see what happens there.
And it's a very important point, which
Massive.
Which court you go to. I mean, it's fundamental.
Love quoting Judge Sutherland. You avoid potentially the long and protracted slog through the tax court if you can go straight to the High Court and they can dispose of the matter. So something that could take you 5 years could suddenly take you 6 months. So I think it's it's massive, as you say, which court you're in and how long you take, and costs and witnesses and so it's hugely important. So well, by the time of our next podcast, hopefully we'll have some news on that.
Yeah, and if one thinks back to the Metcash case, the court used the fact that the taxpayer does have access to the High Court. You can go direct to the High Court, as that was part of the justification for the pay now, argue later rule. And now there's certain decisions that seem to be clamping down on that. Well, then that surely calls the validity of that rule into question. But anyway,
talking about courts, Constitutional Court has spoken in respect of the Arena case. We chatted about that on a previous podcast.
Yes,
so
we
built
did.
up some history in this podcast. So we talk about the High Court, and now we can talk about the Constitutional Court. Whatever it is a year later, whatever it is. And that was, interesting judgment. I mean, nice to see a minority judgment, and like a proper minority judgment, proper majority judgment. Lovely to read.
I remember our previous podcast, and what I recall about that was when you and I were discussing it on the podcast, I had no idea what your views were, and I don't think you knew what mine were, and we agreed. And now hearing you say how nice to see a minority judgment, you take the words out of my mouth. It's so nice to see, what was it, 4 judges to 5. And of course, one of them now is a person who was a colleague of mine for many years on the 15th floor of Huguenot Chambers, Rogers J. Actually, he was on the wrong side this time, in my view.
How view? He was in the narrow majority. I saw that.
And how many? If I can ask an unscripted question, not that anything else has been scripted.
I was going to say.
I just looked. I mean, the judges here, where Zondo wasn't on the bench, so there were 9. 1, 2, 3, 4, 5, 6, 7, 8, 9 judges. I've got the judgment here in front of me. So with Zondo, that's 10. Are they not supposed to be 11?
I thought there were 11 as well.
I suppose you would always sit with an odd number in case there's, you don't want
exactly.
a 50-50 decision.
I thought it was 11.
Oh.
Maybe just to set up the legislative framework for our viewers, just remind them of that. So PIA, the Promotion of Access to Information Act, generally allows you access to information, but obviously it recognizes that certain statutes restrict access to information in certain instances, including the Tax Administration Act. And so PIA accepts and respects that. But PIA then separately has a public interest override provision that kind of says, even if another statute restricts access to information, if it's in the public interest, it still needs to be provided. But the public interest override doesn't apply to taxpayer information. That's in terms of Section 35 of PIA. So kind of a slightly long-winded way of saying, even if there is a public interest override, if there is a public interest in getting taxpayer information, making it available, you can't do so because the public interest override in PIA doesn't apply.
Yeah.
And so the applicant approached the High Court in the first instance and said that that's unconstitutional.
What they wanted was access to former President Zuma's tax records.
Yeah, on the basis that on the face of it, there was non-compliance. They said there's a pretty good prospect that there was non-compliance, shark pose, book, etc. And so they said there's a public interest in getting those records, those taxpayer records of Mr. Zuma, and we think they should be made public. And of course, SARS says, but you can't make them public because taxpayer information is confidential, and the public interest override in PIA doesn't apply in these circumstances. And that's how the constitutional point came in respect of the High Court judgment. And the High Court found in favor of the applicant, Arena Holdings, which holds Business Day, Sunday Times, a couple of other publications, Financial Mail. So to your point, we thought that that judgment basically came out and was appealed then to the Constitutional Court because it was a constitutional point. So it went straight up to the Constitutional Court, and as we said, majority judgment dealing with this, and the majority, I think our view is that came out on the wrong side, if you like, and said that the public interest override should apply in respect of taxpayer information, and that the records must be made available.
So what they actually specifically held was that those provisions which provided otherwise were constitutionally invalid.
Exactly.
Which is what the Pretoria High Court had held. And that was now confirmed.
Yeah.
I was just thinking of an angle on that, which I have read both judgments, and together they come to 80 pages. So it's quite a lengthy thing to get through. And what occurs to me, and maybe I'm unfairly jaundiced or prejudiced or whatever, but whenever I read things in the press about something that I know about in the field of tax, it's invariably wrong, or the slant is wrong, or certain things are overemphasized. And in this case, there were three applicants: Arena Holdings, which, as you said, owned the Financial Mail and Sunday Times and various other publications; Warren Thompson, who was the journalist involved; and then a Center for Investigative Journalism. So it was very much journalistic oriented. So they want access to Zuma's tax records, presumably in order to publish something about it. Now, what guarantee, even if they get given absolutely correct information, surely there should be some control on what is published, because we know, because we debate and discuss tax all the time. There's a lot of tax which is not black and white. There's lots of gray areas, and things get presented by one party in one way and by another party in another way, and You know, I can just see that if certain information is made available, it could be written about in a way which makes some people very unhappy.
I think it's a really important point. And also, tax returns are not as exciting a document as you might think. You know, it just has quite a lot of bland information, and you can easily misconstrue it. And you can say, but hang on, this block was filled in a certain way. Why was that the case? You can, you know, draw your own conclusions from it, which will probably be wrong, because there's not a lot of supporting documentation. It's not like an opinion, you know, you can say, hang on, your reasoning went wrong here, or somebody's written something to someone else. You can say, why did you say that? You know, it's just numbers on a bit of paper, really, and it's become very process sort of driven with e-filing, etc. So the tax return, exactly to your point, Trevor, is not a document where you can sort of say, okay, well, you know, we can see this was wrong because of the reason that is incorrect. There's no reasoning. So I think that's a very, I actually hadn't thought of that before.
And there might be, you know, various globular amounts. You don't necessarily have the breakdown of those amounts. So
exactly. It's interesting how the court also talked about taxpayer confidentiality. Is it necessary to achieve taxpayer compliance? Because that was kind of the argument, and we spoke about that in the High Court judgment, that it's sort of seen as a trade-off, that your taxpayer information is confidential so that you will fully disclose, and those two are linked in some way. And I think we said in our previous podcast that is not really the case. You've got an obligation to file returns. You've got an obligation to submit returns and give accurate information, you know, subject to criminal penalties if you don't. And nowhere in that is it say, you know, you should please do this because, and a sort of a carrot for you to do it is the fact that we won't make your information public. That's not part of the deal. You just have statutory obligations. You need to comply with them. So I've never bought this kind of trade-off concept. And I think the majority judgment sort of, you know, pointed out that that is a nonsense. In fact, they said there's an advantage to criminals in a way, saying, well, if our information can never be made public, you know, that's good news for us, and you know, sort of twist this sort of compact around, and protect their criminality in a way. So, but that link to me is not that important. I've never seen that link as being sort of fundamental to taxpayer confidential information. That's not the point.
The names of the countries that stick in my head from reading their judgment, they said both Canada and the UK have got fairly strict confidentiality rules. You know, they won't disclose taxpayer information, but Slovenia and Sweden are much more relaxed about it. So it's part of the culture of different countries, I suppose. But what worries me is the potential abuse, because I mean, you know, you're getting this information in order to use it for political ends rather than anything else.
And to me, it's not to try and get people to disclose or to get people to submit tax returns. And it's just submit their tax returns. It's a statutory obligation, as I said. It's just to protect the information because it's private information. You know, like people's salaries, what they earn, you know, their general, you know, their wealth or lack of wealth or whatever. That's got nothing to do with anyone else. I mean, that to me is at the heart of taxpayer confidentiality. It's not because you're striking a deal to say, well, if you keep my information confidential, I'll submit my tax return. It's just that it's private information. And I think that goes to the heart of this confidentiality provision. And as soon as you bring in this public interest override, you have points like the one you made, Trevor, but also what is the public interest? When does it apply? Now you have this sort of subjectivity sort of brought in every time you want to, you know, to release taxpayer information. You know, you have this, well, is it in the public interest? And you have to have a debate around that. I like the purity of the law as it was prior to this judgment. But we're on the wrong side, Trevor. It's declared unconstitutional. Constitutional Court has sort of said you must read it in a way where you sort of read in the fact that the public interest override does now apply. And they've given Parliament a certain time period to fix the law. So it's a done deal.
Yeah, I suppose the one mitigating factor, if you have the view that you and I share, is that it's got to be demonstrated that I think it's section 35 of PAIA, that there's a public interest in knowing that information. I mean, that requirement remains. But the court found that was present in the case of Zuma's tax returns. So it's not that everything's going to be disclosed now all of a sudden. It's got to be a matter of public interest.
Exactly, and that's quite a high hurdle, you would think. You've got to be a legitimate public interest. I still don't like it because you sort of what is in the public interest, and you have to have this debate, and it brings into some subjectivity, etc. But at least there is quite a high hurdle before information will be released into the public domain. And I must say, I have seen situations though where taxpayer information has been made public in the sense of the wider public and newspapers and things, but certainly I've seen situations where SARS has told one taxpayer information about another taxpayer. And you sort of often look at that and say, but hang on, these are two different taxpayers. On what basis are you, SARS, providing that information to the other taxpayer? And there are circumstances where they can do it, but they're quite limited circumstances in section 69, I think it is, of the TAA. But I don't see SARS alluding to it. They don't start off and say, we understand that the information is confidential. However, we are providing it to another taxpayer for the following reasons and reference section 69 of the TAA. I just don't see that. I just see other taxpayer information popping up in correspondence. I don't know if you've seen that as well.
No, certainly have, yeah.
And they're criminal sanctions, so it's a bit of a strange one for me that clients have rights as well. And I think sometimes they just need to see whether they want to use the rights that they have in that regard.
Yeah, I suppose it'll be interesting to see how this develops because let's say SARS must now accept that they do have to disclose certain information of Zuma's tax returns, but they'll probably do it in the most minimalist way possible.
As I say,
just to close the bare bones.
Like how long have you been waiting for Trump's tax returns? Years. I don't know if they even come out. I've lost track of all of that. But our tax returns don't expect to get too much information. As I said, they're not that exciting. So there'll be a lot of stuff. And then people will try and put it together, and they might well put it together in a way that's not actually factually accurate. So,
I'm sure they're not going to make photocopies of the actual tax returns available. It will just be information, and information can be dressed up in different ways.
Yeah, but it'll be interesting to watch that space because now they need to do that. Lost the case, need to do that. Constitutional court, no higher court, so that's a done deal then.
Yeah, and I must say I endorse again. It's so nice to see a split decision. Not for its own sake, but for the fact that judges are definitely applying their minds and not just going along with things.
100%, and the minority was well reasoned, detailed.
Absolutely
written. It was just a pleasure to read both judgments, to be honest, and just to see a really, just this.
I mean, I allow me to honestly say, with the greatest of respect to every single one of these 9 judges, I thought the minority judgment was more persuasive, personally.
But we've admitted a certain bias in that regard.
But I'm not saying that the majority judgment was a bad one.
Not at all. Not at all.
Just took different emphasis. Yeah.
And I think our time is probably up there. It's been passed very quickly and enjoyably. So
yeah, it was nice to do this again. And I think there are a couple of things in the pipeline which will require us to chat to each other remotely like this once more.
I hope so. But thanks for that, Trevor, and we'll chat soon.
Yeah, thanks very much. Nice to see you.
The Taxpayer is hosted by the editors of the Taxpayer Journal. Trevor, Emslie, and Peter Dachs. For more information on our journal and other products, please visit our website at taxpayer.co.za. Each of our episodes is CPD certified. To claim your CPD points, please visit our website. Thank you for listening to the Taxpayer Podcast. You can find more episodes on your favorite podcast platform or on our website at taxpayer.co.za. Please like and subscribe on YouTube and rate our podcast on your podcast platform of choice.